Oh, thank you. Each lender is in business. The bottom line for them is profits. Therefore, the more they lend, the more they are able to make in terms of profits. That is assuming they are able to recover. In this day and age, lending has gone digital, so that persons do not have to go to banks anymore. The persons who want to borrow merely do so at the click of a button. This makes it easy to borrow, and everybody who wants to lend is encouraging every person in Kenya to borrow. And yes, they are succeeding. The difficulty is that whereas previously you had a situation where the borrower would go and talk to a manager and would be asked questions and would be assessed for suitability as to whether or not he can pay back the amount he has borrowed and what he wants to use the money for. Now, nobody asks you any questions because they are so eager to lend, and you want money, they simply give it to you. What this has done is to create over borrowing, because I can borrow from 4 or 5 different platforms. None is the wiser about the other. The net result, I am not able to pay. And whereas the lender was happy to give me the money, they'll soon become unhappy when I am unable to pay. So, the lender therefore has an obligation in the long run to protect not only their interest in the profit, but to protect me, the consumer, against myself, lest I borrow too much because it is very enticing. Therefore, whereas digitization is the way to go, banks and all lenders may very well have to have a rethink about incorporating some element of subjectivity where they have an opportunity of engaging with the borrower. That gives protection to them as lenders and to potentially bad borrowers.
I find that to be a very comprehensive response to consumer protection. I'd like to hear your thoughts on dispute resolution, especially why we're encouraging lenders and borrowers not to come disputes at the judiciary first and to go visit alternative dispute resolution centers. You could cite examples such as Tatua's.
When people are in dispute, and this is normal in any community, the natural way of resolving them was, in the first instance, talking to one another, either directly or in the presence of other people, such as elders. I have long advocated for the drop of the use of the phrase alternative dispute resolution. What comes naturally is discussions, negotiations, conciliation. But now people believe more and more that if we have a dispute, we see you in court. So it is as if litigation is the first pot of call. So that which used to come naturally is now deemed to be alternative to litigation. But litigation is impersonal. The winner takes it all. The person who adjudicates only adjudicates on the basis of the evidence and the issues as presented. We do not dig deeper to find the reasons which inform the dispute. You may be unable to pay your loan. Perhaps it's because of an underlying reason. Maybe because your parent fell ill. you lost somebody in the family. And during that trying time, you are unable to service your loan. Those are not issues for determination through litigation, because litigation merely deals with the question as to whether or not you borrowed, and if so, whether or not you had paid. If you have not paid back, we will give judgment against you. Whereas if you go to mediation, which currently is being run by the judiciary, or a court and next mediation, you do not pay a cent more than you had already paid to your lawyers and as court fees. The judiciary pays the mediators. And it gives the parties an opportunity to talk even about underlying issues to find a solution to their problem. Hence, judiciary calls it a solution by you, for you. The parties themselves craft a resolution. Because they do so, they don't ordinarily need to go to the stage of execution, because they have resolved it, they have agreed on what is best for both of them.